Assalamualaikum warahmatullahi ta'ala wabarakatuh. Bismillahirrahmanirrahim. Today I would like to present the topic on the Islamic Family Law Enactment, State of Pahang 2005 and the Law Reform Marriage and Divorce Act 1976, the study and position of underage marriage. Okay, this paper was co-authored by me, Nur Adaha binti Abdul Hamid, and Fatim Farhanis Mah Hussein from Kolej Universiti Islam Antarabangsa, Selangor. The contents of presentation is on the abstract, the introduction, methodology, literature review, analysis and discussion, and also the conclusion. Okay, the abstract. Underage marriage is not a foreign issue when it comes to the continuous debate of morality among the Malaysian populace. This issue became a heated debate on social media when a case of an underage marriage in Kelantan involving a 41-year-old man who had married an 11-year-old girl became known to the public. So this raised the pertinent question of whether or not an underage marriage should be permitted in the first place. So accordingly, this paper refines the content of the discussion in relation to the position of underage marriage based on the Islamic law and legislation. Okay, as an introduction, according to Islamic law, the term child is used as a reference to someone who has not reached the puberty. Based on the definition of child from the Arabic point of view, according to Ibn Manzur in the Arabic Oral Dictionary, as-sighar is defined as something opposite of large. It is also could mean being of lesser in size or lesser of age, so he is regarded as as-saghir or small. In terms of terminology, the word as-sighar carries the meaning of a feature which can be associated with human being from birth until puberty. According to civil law, the term child is defined as a boy or girl who is still young in the age and also it is usually no older than 7 or 8 years of age. Under Section 2, Clause 1 of the Child Act 2001 defines a child as a person under the age of 18, while under Section 2 of the Age of Majority Act 1971 provides that the age limit to be categorized as a child for both men and women is limited to 18. According to 1989 Convention on the Rights of the Child, the United Nations Children's Fund UNICEF, Article 1 of the UNICEF, a child is defined as someone who is under the age of 18. Okay, underage marriage according to Sharia law, the proof regarding the call to marry can be found in Surah An-Nur verse 32, where in it Allah subhanahu wa ta'ala decreed the following, means that, and marry those who are single, men and women, from among you, and those who are righteous from among your servants, men and women. Single here, men and women, as referred to in the verse, are unmarried women, whether child or adults. Marriages can be held for women who are still children and for those who have reached the puberty. Allah subhanahu wa ta'ala also decreed the following in Surah At-Talaq verse 4, which means that, and women among you who have stopped menstruating or menopause, if you have doubt against the period of the iddah, then the iddah is set at 3 months, and likewise is also the iddah for women who have not begun menstruating. And among the narrated hadiths relating to the age of Aisha radiallahu anha in her marriage to the Prophet sallallahu alaihi wasallam is as follows. While Aisha radiallahu anha was married by the Prophet, peace be upon him, when he was 6 years old and was with him was 9 years. Sahih al-Bukhari and Sahih Muslim. So through this hadith, most jurists opine that this is a khususiyah or special case only applicable towards the purity of the Prophet, peace be upon him. This is so since such marriages also did happen to other friends of the Prophet sallallahu alaihi wasallam, namely the marriage between Kalsum, who was 10 years of age at the time, and Sayyidina Umar al-Khattab. Okay, the methodology employed under this study is through a qualitative approach through the documentation method by analyzing cases of underage marriage in the Sharia Subordinate Court of Kuantan, and also with the statistic from the year 2013 to 2018. Being a library-based research tool, reference will be made to relevant authoritative texts, the case studies, and applies the method of literature reviews through the content analysis of documents. Here is the literature reviews. Okay, under the Islamic Family Law Enactment, State of Pahang 2005, whereby this enactment was initially gazetted as the Islamic Family Law Enactment 1987 on 20th May 1987 by the Sultan of Pahang, who had agreed to codify certain provisions of Islamic family law regarding marriage, divorce, alimony, custody, and other matters relating to family life, and came into force on 1st May 1988. Following that, the enactment came to be known as the Islamic Family Law Enactment 2005. This enactment only applies to all Muslims settled and living in the state of Pahang only. And under Section 8 of the enactment provides that no marriage shall be solemnized if the man is less than 18 years old or the woman is less than 16 years of age, unless prior written permission due to certain circumstances is provided by a Sharia judge. Meanwhile, Section 18 provides that if one of the parties of a marriage is underage as highlighted in Section 8, then the registrar shall instead act under the provision of Section 17 and refer the said marriage application to Sharia judge who has jurisdiction in the state or district where the woman resides. Section 12 Clause 2, on the other hand, provides that a marriage performed in violation of any legal provision of the law but is still found valid in accordance with Sharia law, it may be registered under this enactment by order of the court, subject to a penalty prescribed under Section 40 Clause 2, which carries a fine not exceeding 1,000 ringgit, imprisonment not exceeding 6 months or both. So here, the effect of the provisions underlined in Section 8, Section 12 Clause 2, and Section 53 Clause G may be summed up as such that a marriage shall not take place under this enactment if the man is less than 18 years old or the woman is less than 16 years old. Such a marriage also, if committed in violation of the enactment, may be registered subject to a penalty if the court so decide after being satisfied that it is valid in accordance with the Sharia law. Under the provisions of the Law Reform Marriage and Divorce Act 1976, it is only applies to non-Muslims living in Malaysia, which includes any Malaysian residing outside Malaysia. This act does not apply to the native of Sabah, Sarawak, and also the indigenous people in Peninsular Malaysia. And under this act, the minimum age limit set for a marriage of minors is 18 years old, which is provided under Section 10. Any marriage purported to be solemnized in Malaysia is invalid if on the date of the marriage, one of the parties is under the age of 18 years, unless if for a woman who has reached the age of 16 years, the marriage ceremony has been authorized by a license as granted by the Chief Minister. Thus, anyone wishing to marry but are under the age of 18 must first obtain a license. Now we go to the analysis and discussion. Okay, I put here under 3 subheading. The first one is on the case studies. We have 4 case studies here. The first case study is for the applicant A, whereby the applicant applied permission for an underage marriage. The applicant admitted that she was not forced by anyone to marry, and that this marriage was of her own volition. Okay, in the presence of the applicant and her father, the court heard all the evidence presented by the applicant and her father, after which the court decided to allow the applicant to marry at this age, as there were also no barriers to it according to Sharia law. and this permission was issued in accordance with Section 18, Clause 1A of the Islamic Family Law Enactment, State of Pahang 2005 on 12 March 2020. The applicant is 14 years old. For the case study B, applicant B, the applicant is 16 years old. The application was heard and resolved in the presence of the applicant alone after the court examined and heard the affidavit and references from the registrar, and the court allowed the assistant registrar to solemnize the marriage of this couple according with Sharia law and the state Islamic Religious Law Administration enactment. For the third case study, applicant C, age 17 years old, applied for the court for an underage marriage permission along with his partner, who was 18 years old. After the court was satisfied with all the evidence given, then the court allowed the applicant to marry his partner on 27 May 2019 under Section 18, Clause 1 of the same enactment. And the fourth case study, applicant D, age 17 years and 9 months, applied for a marriage permission with his partner, who was 19 years, and the court allowed this marriage to take place under Section 18, Clause 1A of the same enactment. Okay, the study carried found that among the factors that lead to underage marriage in the state of Pahang, among them are having divorced parents, which causes children to lack of the family love. Second one is getting carried away physically with a partner. The third one, getting pregnant out of wedlock. The fourth one is on the social influence, and finally the lack of interest in education, followed by the decision of quitting the school. For the underage marriage statistic in all Sharia subordinate courts throughout the state of Pahang from 2013 to 2018, as we can see here, the number of underage marriage cases that has been registered is about 428 cases, where all said registered cases has been resolved with no cases still in proceeding. So, statistic of underage marriage applications approved in the state of Pahang from 2013 to 2018, as we can see here, the total number of the applications approved from 2013 to 2018 is approximately 60,779. In 2016, it boasted the highest number of applications approved at 12,545 applications as compared to 2013 with only 3,326 applications. The Kuantan Islamic Religious Office has approved 13,216 applications over the past 5 years, with the most applications being approved among other Islamic religious office in the state of Pahang, while the least number of approved applications came from the Cheno Islamic Religious Office. As a conclusion, the Pahang state government still maintains the minimum age of marriage of 16 years for women and 18 years for men, as contained in the Islamic Family Law Enactment, State of Pahang 2005, as quoted by Metro 2018, with no actually any intention to amend the minimum age of marriage to 18 years as proposed by the federal government, which was based on the statement of the Mufti. Okay, so the study found that marriages involving minors will need prior permission obtained from the court before the marriage will be allowed to initiate the marriage application process at the District Islamic Religious Office. Also, as a conclusion, we can conclude that Islam allows for marriage before the age of 18 under certain conditions. Therefore, the proposal to absolutely ban the underage marriage will undermine the principles of justice and humanity afforded to couples who intend to get married to avoid getting caught up in the stigma and negative aspects of being linked to adultery, as well as be denied the rights to happiness while they have the maturity to take on the responsibility of a marriage even if they were under the age of 18. So with that, I conclude the presentation. So thank you. Thanks very much and shukran. Assalamualaikum warahmatullahi taala wabarakatuh.